the accident
So you're
happened.
conceding that plea?
No,
You
no.
want to Send it back?
No, not at all, because actually, we have so much more. We have a facially deficient, yes, sir.
Laurie, there's something beeping over here, do you know what? Well, why don't you turn it off, and I'll just use my watch, because it's annoying me.
Really, I'm going to roll back a little bit to the original main argument in this case, which is that it is an unenforceable arbitration agreement. And unconscionability issues aside, the most important fact is they have rejected the Florida Arbitration Code by requiring that Georgia law be implemented. Demora, Knight Equity, Romar, three very important cases that all say unequivocally where parties elect to choose the substantive law of another state, then it is a rejection of Florida's arbitration code, and that arbitration clause becomes voidable. And that's what we've done here. I think Romar, the court found that the arbitration clause would still be enforceable because the party essentially didn't elect to void the arbitration clause. I think it counterclaimed, and by counterclaiming, then it sort of perpetuated, and you can't claim arbitration after you've already taken those steps.
So what you're saying is that all of the arbitration agreements in like the securities with the big securities houses for securities litigation that say that New York law or Delaware law applies, and they're suing on them, somebody sues them here, that they can elect to void all those?
It is an election. Well, the parties can agree, certainly, and what usually happens in those types of security cases is nobody attacks the arbitration clause, and the parties agree to go ahead and litigate applying New York law. You can arbitrate in the state if the parties agree.
I don't think you're
but
right.
it is.
I mean, I think that there's a lot of people who very unhappily arbitrate because they have to under New York law. You're saying that we can just, a Florida resident who engages with signs a contract with a out-of-state, maybe a multi-state company that has an arbitration clause that applies.
The agreement between the parties called for arbitration and required arbitration in New York law. And more, the Florida Supreme Court said, by including that provision, by choosing that other state law, then one party had the right to object to the arbitration provision. It doesn't mean that there's no remedy for that. It just means that if you're going to apply state law, you're going to do it in circuit court. And in fact, it reminds me of the BDO case, which was cited by the appellants in this case. There was an interesting opinion, a good opinion, authored by Judge Warner, I think 2 years ago. And in that case, it was a securities broker who was in litigation with a securities house. They had a contract, and this was a well-litigated securities agreement, or employment agreement. And in that case, the broker waived the right to object to arbitration because he was actively litigating the case and had claims. So this court's finding or holding in BDO is not at all inconsistent with the Supreme Court in Demora, nor is it inconsistent with Knight Equities.
Let's assume for argument's sake you're correct, and so you want to void the agreement, and the judge says, okay, no arbitration, but I've still got a venue provision, I've still got a conflicts of law provision, what do I do? What happens then? What's wrong with the venue provision, and what's wrong with the, and I don't know that the judge even addressed the venue provision, I don't believe he did, but what about the conflicts? I mean, would you still apply Georgia law to your case?
Absolutely not, Your Honor.
And why not?
Because this agreement to arbitrate is literally in a box in this one-page document. It is all so intertwined that you cannot separate it. It literally flows in the same sentence. ATP at its sole election may choose arbitration at its sole election, and if it does so, it will apply the laws of Georgia, and it will happen in Jacksonville. There is no way, when we have a large contract that contains terms, like Judge Warner was referencing, describes what the parties have to do. Then you say, okay, here's an obligation, here's a remedy, here's a choice of law provision. I don't like that so much, we'll cut that and separate that out. But when you have one-page document, nearly all of which is consumed with this issue of arbitration. And it's literally in two sentences, one or two long run-on sentences. It is indivisible. And there's case law on that as well, that where you have a contract which is so indivisible from the choice of law provision or from the venue provision, then that the entire contract fails.
You're relying on Demora to a large extent. Demora isn't the facts of this case, because in Demora, they said arbitration, the whole proceeding will be out of state. And what we said is, well, when you're moving out of state, then you're not relying on the Florida arbitration clause, and you can void it because you bring a suit in this state. Actually, there's no authority for the courts of this state to order something to happen in another state. So it's a real problem. But here, they're actually going to arbitrate in this state.
I love that the court brought that point up, because it's important to note that in Romar, also a 4th BCA case, there was not a requirement that the arbitration take place in or out of the state. In fact, in that case, all it said is that you would apply the law of Trinidad and Tobago, but did not require that the arbitration take place in Trinidad and Tobago. So the appellants argue that the problem with those cases, and the reason why they're not applicable, is because, well, they require an arbitration to take place out of the state, and therefore Florida's divested. That's not true, because Romar contemplates the application of substantive law of another venue, of another jurisdiction, but it does not say that the arbitration will take place out of Florida. So the key holding in Zamora and Romar unite is the application of another state's law, not whether the arbitration.
Counsel,
I do apply other states' law all the time in agreements, insurance agreements, everything else. And what you're saying is, if an agreement applies some other state's law, we can void the agreement. Now, that's clearly a violation of anything, a full faith and credit or something. I mean, that just doesn't, well, I think that your reading of these cases is
I respect that, and I understand the court's position on that. There are other opportunities that a party has in order to get the case into arbitration. There's the FAA, which they have well argued that doesn't apply in this case. The parties are not foreclosed from remedies as a result of what I'm suggesting the case law holds. If there was any other reason under the Warren Knight or Romar that held another way, that left that door cracked, so to speak, then we would certainly have to respect and argue that and discuss it. But they don't do that. Their holding in those three cases is very clear. If you try to apply another state's law, then one party may void that arbitration agreement.
Counsel, I got to correct you on something that you said to us. Well, I would agree that the provision you refer to is in a box entitled Agreement to Arbitrate. It's not in one sentence. And in fact, if you look, it's about 5 lines from the bottom, and I'm quoting directly from it. Parties exclusively select the application of Georgia's substantive law without resort to Georgia's conflicts of law rules to resolve legal issues that may arise in the course of such arbitration or any litigation between the parties. That's one sentence. Next, should any such controversy arising from or related to this agreement or any other agreements or dealings between the parties be litigated rather than arbitrated, the parties select as the sole and exclusive venue for any such litigation the state and federal courts in Jacksonville, Florida. Those are 2 separate sentences, 2 declarative statements. It's not one sentence tied into the sentence dealing with arbitration.
I understand, Your Honor, but to the extent that it's